one of the things that interests me, and I'm sure you can appreciate this, is as I'm looking at this case, I keep thinking about, what would happen now with today's court rules and rules of evidence. How would this trial have played out? And one of the pieces of evidence at the trial was all of this testimony regarding the wood from the ladder. And, as you know, the scientific reliability of certain types of evidence is often challenged by defense attorneys, and the courts have created different standards with regard to, the reliability of scientific evidence. Explain for us the issue with the wood from the ladder and how the prosecution attempted to prove their case through what they argued was, kind of airtight evidence in the forms of scientific, evidence.
Well, the police took over Hauptmann's apartment the day of his arrest, and it wasn't until a couple of weeks later that they made this claim about one rail of the ladder having been planed down because it was only about 3 3/4 inches wide, and from a floorboard which originally had a tongue and groove, which were not present on the rail. And they said there's a missing 8-foot piece approximately of a floorboard in the attic, and it was cut down to make this little over 6.5-foot rail. Hauptmann immediately, when he heard about it, said the police must have manufactured that. There were super problems with the way this was handled, which wouldn't be handled today. Number one, the wood expert that they brought in did a visual comparison, which they don't do anymore. This today would be wood DNA test to compare the rail to the piece of floorboard that was brought into court from the attic. And that's something I would like to see done today. It has never been done, but the police have kept both pieces of wood. There were other issues about it. The defense experts today would have been given access to that attic. They were never given access before or during the trial, even though they demanded it. They barely got any time to look at the wood samples in court before they had to testify. Also, today, the state expert would have had to disclose the extensive notes that he had taken pre-trial, none of which came to the defense, and many of which were inconsistent with his trial testimony.